Welcome everyone. So we've got a good turnout in the classroom, and I know we have some people online as well. We've got a limited time slot, so I'm going to go ahead and get started. Those of you who are getting pizza, no rush. Feel free to get your food and filter in. I will give a very brief introduction of our three panelists, just in the interest of time. So I apologize for these very concise introductions, but we have Larry Bridgesmith, who has a very varied background, and among many other things, he is an adjunct professor at the Vanderbilt University Law School. He is the founder and chief executive officer of Creative Collaborations LLC and chief academic strategist for ODEM. We have Daniel Linna, who is a senior lecturer and director of law and technology initiatives at Northwestern University's Pritzker School of Law and the McCormick School of Engineering. And we have our own Professor Kristen Thomasen, who is an assistant professor here at the UBC Law School, and some of you may know her from your classes. So with that very brief series of introductions out of the way, I think we'll go ahead and jump into our questions, and we'll see how many we get through. I'd like to leave some time at the end for audience questions. So the first question, and this is, I don't know if necessarily all of you need to answer this. We could maybe have an answer from the Canadian side and then an answer from the U.S. side. I should mention Professor Thomasen's obviously here in Canada, but Larry and Daniel are both in the United States, so we can get a kind of comparative perspective on these issues. So the first question is, could you just sort of set the groundwork in terms of what is the existing regulatory framework for artificial intelligence, generally speaking, in Canada on the one hand and the United States on the other? And I'll just kind of let people volunteer to answer this question. So Kristen, maybe you could go first.
Yeah, sure.
I'll volunteer you.
Voluntold. Yeah, so in Canada, I mean, as of right now, what is actually in force is largely guidance and not necessarily sort of a strict regulatory regime that is particular to AI. So the federal government has some guidance, including guidance that is, it's mandatory for people who work in the federal government, but it's not legally binding. It's not more broadly applicable. So beyond that, the laws of general application, we would say, apply, like undoubtedly would apply to AI. It's just that there is some unclarity in how these laws might apply, given some of the particular features of how different automated systems work. So, tort law, my area of specialty, undoubtedly would have some application to AI, but with, some things to be clarified. And then, our privacy laws, a whole range of different laws would apply. That said, in Canada, the most significant thing happening right now, in my view, is the development of the Artificial Intelligence and Data Act at the federal level, which looks to be a federal law that would regulate the commercial development and use of artificial intelligence. It's limited in some key ways, and it's also under study right now. And it would sound to me, I mean, this is my anecdotal insight onto it, like there's going to be some heavy amendments recommended to the law before it goes back to actually be voted on. So, I preface with there's a little bit of unclarity or uncertainty around what it's actually going to look like. But the basic structure is that that it's going to target only commercial development and use right now. And it's going to look at what are called high impact systems. So it's a limit on what types of systems will fall into the scope. It's mainly looking at reporting, like risk mitigation thinking within the company. So identifying where there might be certain kinds of risks, and then keeping records and reporting on whether the company's done something to mitigate those risks. And if those risks do materialize, reporting that as well. There are some hefty penalties if the companies that are using AI fail to do this. But there's also still some uncertainty in terms of this is largely self-administered. This only applies to certain systems. The government, I think, has tried to be a little more expansive in what kinds of harm are relevant. So they include physical harm, psychological harm, which is interesting. I think it's important and worthwhile. And they also include biased outputs, which really what they mean to say there, I think, is discriminatory bias that can result from systems. So they're targeting some important areas. There's a companion document that was drafted alongside the legislation that personally I find actually more helpful than the legislation itself. But like I said, we're waiting to see what some of those amendments might look like. So if you're really interested in this, it's the Industry and Technology Committee that's currently engaging in a study of the proposed legislation. There have been a ton of submissions from a range of different stakeholders, including I myself worked on one with the Women's Legal Education and Action Fund. We took an equity lens to the legislation and identified some weaknesses in it. But that's sort of the key regulatory development that's happening in Canada right now. That said, there was also an announcement just this morning that British Columbia is going to enact legislation that would allow the province to sue social media companies, including, this was noted in the press conference, we haven't seen the law yet, including for the use of addictive algorithms. Or using algorithms to get people addicted to using different social media accounts. So that's not so much regulatory as, again, we're going back to tort law, but just the province would make it clear that at a provincial collective level, we might see litigation that looks to reclaim some of the public harms that arise from certain types of uses of algorithms. So there are these sort of one-off instances as well happening across the country that'll be interesting to see if other provinces follow suit. So yeah, I'll be following that very closely, but that's sort of where we're at right now. Is there's a lot of guidance, but we don't have anything in force strictly applicable just yet, but it looks like it's coming.
So clearly an emerging area. And then I guess you can choose between either Daniel or Larry, maybe just one of you kind of just give a quick overview of what's the current landscape in the United States, either at the state and or the federal level.
Well, Dan is free to correct misstatements that I might make, but we are pretty much in the same situation that Kristen just described. There is no comprehensive regulatory framework. The most active initiative has come out of the White House. President Biden and his team issued an executive order which provided guidance, but nothing mandatory, and the various federal agencies have taken up the cudgel, being led primarily by the Federal Trade Commission here in the U.S., who seeks to sort of overarchingly speak for the federal agency complex, but specifically there have been some local enactments, such as the New York City enactment, which governs bias in hiring, as well as a more generalized enactment that requires display and some degree of transparency with respect to AI that would impact the citizens in New York City. But I think that it's also pertinent to note that the collaboration between the US and Canada through the Regulatory Cooperation Council is designed to help reduce any kinds of intrusive differences between the regulatory systems. So as both nations come to the table with comprehensive legislation, I also would look forward to seeing how the two nations coordinate those approaches.
So I'll just jump in quick, Larry, and I'll add so I agree the Federal Trade Commission is doing a lot in this space. And that's one of the things the executive order that President Biden issued, I think, is there we'll see more administrative agencies taking action in this space. The Federal Trade Commission has jurisdiction over unfair and deceptive practices that affect consumers. That's pretty broad, and that's a lot of the things we're worried about in the way that AI might be used. A fundamental concern here, I think, is really about data privacy and security. And so that's something that's lacking in the US. We don't have a GDPR-like statute. We don't have that at a national level. There's some things happening in the States. I think you're going to see many, many more opportunities for states and local governments. And the whole idea of federalism, right? This is what we should want to see, is that states and local governments are going to do things in this space. There's biometric information privacy acts in Illinois, Texas, Washington. That's an example. There are some other privacy laws in different states. The state of Washington put in place a comprehensive law on using face recognition technology in policing and by governments. I think that's a really interesting example of regulating AI. And that gets to some of the specific harms that we might might be concerned about that really kind of go beyond privacy, like what is the accuracy of these different AI tools, things like that. And it's great Kristen mentioned tort law. I mean, 10 years ago, maybe even just 5 years ago, people were like, it's the Wild West. There's no law that applies. It's like, well, hold on a second. There are some gaps, but we have laws in these places, and tort law, product liability law is a good example. So we have some ideas. There are some interesting questions, and it's not clear how courts will handle those interesting questions. But also something that's really important to recognize here is that many of the harms are very basic things, and terrible uses of the technology that are just not thinking about simple things. So there's a lot of very basic sort of harms and in law in place that could be used to protect people. And then we just have to think, I think, about where are the gaps, right? What are the issues that are kind of left open where we need legislation at a federal level, state, and local level.
Okay, great. So it sounds like in both Canada and the United States, there's a fair amount of existing law that is relevant, but there is not yet any comprehensive regulatory framework addressing AI specifically. So I want to kind of shift to talking about generative AI, just because that's, in the last year or so kind of captured the public attention. I'm sure it's something that a lot of students are interested in. So, kind of given the absence of any comprehensive regulatory framework, what in the minds of our three presenters, what needs to be done on the regulatory front to address generative AI specifically, whether it's the generation of text or images or other forms of media? Like, what's the next step that governments need to take? Maybe to facilitate things, I should probably ask you guys to speak in order. So why don't we go maybe kind of in the same order? So we'll just kind of go clockwise. So Kristen, would you like to start out?
Sure, yeah. Well, and there's an interesting legal comparison here as well, because in Canada, we don't have limitation. We don't have any kind of statutory restriction or limitation on liability for platforms or producers or whatever the case might be. So, because the reason I mention that is the first thing that comes to my mind when we're thinking about generative AI is, we do have negligence law already out there and product liability law. We have copyright law. We have, laws that can apply to some of the key legal issues that have been raised recently, at least with generative AI, which includes things like, taking artwork or creations and using them as training data and then creating a product. And, the question of whether there's any violation of copyright in that process. Privacy and, my images have been taken from the internet. That feels like a privacy violation. There's questions around that. We do have privacy laws. Again, it's not totally clear how those are going to apply, but we do have laws that can relate to those sorts of issues. But what I've been thinking of in the last 48 hours, because I imagine some in the room might have seen, but there is now a very high profile story about a synthetic intimate images of Taylor Swift that were created using a generative AI tool, like an image creator. And so, the people who used it, it seems from some investigative reporting, used some fairly simple workarounds to the filters that would have otherwise prevented the creation of an intimate image using this tool. And there's a range of issues there, but a huge one is that this is an incredibly harmful use of the technology to be able to create a synthetic, damaging image, like a synthetic intimate image, and then to have it spread really rapidly on social media as well. And, the question around responsibility, right? And how are the creators of generative AI tools responsible, if at all, for the outputs, even if the output only exists because a third party used the tool to create that output? And so where does the responsibility lie? Again, I think negligence law is an area of law that can apply to this, but it is entirely possible that we're going to need better guidance, either from the courts, but ideally really from legislators, like a little bit more prescriptive guidance in terms of responsibility if you're creating a tool that can be quite powerful to be used for, obviously good outputs, but also quite negative and harmful purposes. So my take is that with generative AI, the other panelists can push me on this if they want to. I don't think we're seeing anything that's so legally different that we have to like create a whole new legal regime to deal with generative AI. But what I think would be beneficial, especially coming from sort of the government legislative prescriptive level, is greater clarity on who's responsible for what, who's responsible to whom. How can people seek out maybe compensation where it's deserved or some kind of other vindication where it's deserved? Just to make it more obvious to people who are seeking a legal response to something that has happened. Where do they go and are they going to be successful? Because otherwise, what we're really doing is waiting for really wealthy litigants to solve this for us. And I think that is an access to justice issue on a few different levels. So, but I open it up to the other panelists to see what they think too.
Sorry, I'm in violent agreement with Professor Thomasen. The issues that are already manifest in the U.S. include issues with respect to copyright and who's entitled to the production that comes out of a generative AI machine, who has rights to the training material that have been introduced into the large language model. And to this point, there has been little common law or generalized law that has protected these unique and new issues that is created by generative AI. For example, we have in the US a copyright office of 450 people that manage all the copyrights. Well, that's wholly inadequate to the task that generative AI could very well impact. And we're seeing these issues arise, and yet the courts have little guidance. So what I completely agree with Kristen on is the need for these frameworks within which we can make judgments, even if they are not statutory or regulatory yet. Let's certainly begin to create some standards around responsible AI. And last week in Davos, the World Economic Forum, the number one issue that was identified by the world's economic leaders was misinformation and disinformation, the hallucinatory effects of generative AI, and uses such as the example that Kristen gave regarding Taylor Swift and countless other celebrities. It really is beginning to become very, very blatant and very, very pervasive. So these are things that need to have guidance for the standpoint of the litigants, but we also need guidance for the standpoint of the marketplace. How do these responsible AI platforms work? How should they work? And what is the parameter of responsible AI, ethical and legally compliant AI? So we're still waiting for those guidelines.
Yeah, so I don't think anyone knows what the answer is to this question, frankly, because generative AI is such a big question. And I think now the examples that Kristen and Larry talked about, I think that's what's key is we have to really zero in on specific things. Even in the European Union, they've been thinking about this for a long time. They had GDPR, they've been thinking about these issues. And then all of a sudden, large language models and ChatGPT came out and they're like, oh my gosh, like, how is this covered? Is it covered? Now, the executive order from President Biden raises some national security concerns and talks about if you're using these foundation models, these big models capable of doing many things, that there'd have to be certain disclosures to the government, so that we might see some things like that. But it's so important that we identify the harms that we're thinking about. And I worry about so much of the work in this space just focusing on the risks and not thinking about the benefits. These technologies, in my view, are going to transform the economy, the world of work, what it means to be a lawyer, what the rule of law looks like in the future. And so we need to be preparing. We need policy that's preparing us for the future, training people, making sure they understand these things. Policies in law schools. I don't happen to know the specific policy in your law school, but I worry because many law schools are starting off and kind of saying, oh, we're going to ban it. We're going to ban generative AI. Like, why? What are the risks? What do you think the harms are? Our students need to learn to use these tools, right? And use them responsibly and use them well. So, identify that. I think from a policy perspective, even just thinking inside of our law schools, this is what I'd hope lawmakers would do, not have knee-jerk reactions to this, but really think carefully. Well, what are the specific harms? What are the benefits of these tools? How do we maximize, put in place policies that are going to produce more benefits than risks? And as far as these responsible AI principles, there's been a lot of discussion around them for nearly a decade. And we're seeing many companies put those in place. And so I'm in New York for the PLI AI Law Conference. A lot of companies, they're putting these in place. They're developing procedures, documenting the things they're doing because they anticipate there will be lawsuits. So liability will be determined. There will be regulatory actions, and they want to demonstrate that they're complying with these responsible AI principles. But we also see a lot of failures. The Rite Aid in the U.S. that just came out, they're going through bankruptcy. They were using face recognition technology in a way that was totally irresponsible, making all kinds of errors and labeling people as shoplifters. And then they didn't train their employees, and their employees were confronting people and accusing them of being shoplifters. So terribly inaccurate, worse yet, terribly biased. If you're underrepresented minority, a lot more likely that you'd have a false positive and be, targeted as a shoplifter. So I think things are getting better. There's a better understanding of what the proper principles are, but there's still a way to go to make sure that these are being applied properly, I think, in different organizations. And then we have to just really think carefully, I think, where are there specific sort of failures? Deepfakes is an area, right? There's some things to be done around that, I think. But misinformation has been around for a long time, right? We're not going to solve that whole problem. And, there's some areas here, though, I think where law is needed to help solve that problem.
Okay, thank you very much. So I'm actually going to skip over my next prepared question because I think your answers to the preceding question actually address it to a significant extent. And I think that your answers also segue really well into the question that comes after. And so that question is, what are the potential risks of over-regulating AI, right? And how in our regulatory approaches do we mitigate those risks? So I'll go in the same order.
So, I think, and I hope the other panelists will jump in on this as well as they see fit. But I think a common conclusion that we go to, not jump to like it's incorrect, but that we go to is, one of the risks of over-regulating is that we're going to lose out on some of the benefits of AI. And so while I'm not going to disagree with that, I actually think that there's also an issue where over-regulating or over-hyper-focusing on specific, to borrow Daniel's term, like knee-jerk reactions are going to lead to missing some of the more pervasive ways in which systems that are automated can cause harm, and also can lead to a hyper-focus on the concept of AI, which really has become like an umbrella term that means anything and everything that is like tech and maybe automated and maybe not even, and can lead to missing some of the bigger or some of the deeper root causes of some of the issues that we're really trying to address, or the lawmakers might be trying to address. So as much as I concede and I'm happy to talk more about like how overregulation could cause a loss of benefits from the tools, my bigger concern is how like an idea of overregulating a particular issue is going to cause the people with the power to do something to miss whole other swaths of issues that are really pertinent and can be harmful. So I would say, like, including into the AI and Data Act, the idea of discriminatory bias is a really important and valuable step. And I think touches on something that I'm talking about, where like we might be so focused on one thing that we miss another more pervasive one. And bias has been widely reported as a result of, either it's the biased data or sometimes it's actually in the algorithm itself. But having these really impactful biased outputs can be really harmful to people. But at the same time, ADA is focused only on commercial actors, only on really specific systems. And I think is also really focused on trying not to lose the benefits of the system, to the point that it's arguable. Some have argued that it's actually not really doing a whole lot anymore anyway, although we are maybe getting some clarification of the minister that's going to expand it. But ultimately, like, we're not even talking about like individual uses of AI systems and the way that that can cause harm and how that fits into the legal system. We're not most maybe significantly talking about how the state uses AI and what discriminatory bias might mean. And we're also not really necessarily thinking about how like AI, however it's defined, there's a definition in the proposed legislation, how it intersects with things like social media, or, you know, like sharing platforms with internet intermediaries. And so a lot of these sort of bigger systemic questions can be missed, and I think arguably are being missed to some degree in Canada, because of a hyper focus on like backlash or knee-jerk reaction to specific issues. And also, sorry, this is a bit of an aside, but we have to drop the like AI is going to destroy humanity focus, at least for lawmakers and legislators. Maybe it's interesting in like ethical conversations, in terms of like getting things done right now that are actually going to deal with some of the harms that are created by different automated systems. But I'm eager to hear what my panelists think as well, co-panelists, sorry, think as well.
Well, it's ironic that when we talk about AI, there are probably over 90 distinctly different kinds of AI applications. So you have to ask in response, what AI are you talking about? What kind of application? Everything from spell check to word finder, all kinds of automatic AI support have been in existence for many years, and we've come to rely upon them, from our Siris to our Alexa. The more complex the AI becomes, I think we see most of the attention focused on generative AI when we talk about regulating AI. But that's what the problem is in terms of regulation. Because if we don't identify the specific risks that we're seeking to address, the consequence of over-regulating is to stifle innovation. And this is not a single professional segment response. In other words, this is a multidisciplinary matter that if we're going to regulate AI, we have to have collaboration between professions, between industry, government, and academia. This can't be a sausage, as we say in the US, made out of a secret sauce in a private space, and that's our law. We have to bring a very highly public awareness and educational effort into this process of regulation. So we're not acting in reaction, but we are actually being proactive in identifying the things that we need to protect from. I agree with Dan and Kristen. AI is here to stay. It is not going to go away. We can't outlaw it. And to Dan's suggestion about academia, if I'm not training my law students in how to use generative AI and its risks to be avoided, then I'm failing in my learning responsibilities. So I always bring into whatever subject matter I'm teaching the applicability of generative AI, but let's learn how to use it well. Let's understand what the risks are, and let's practice responsible AI usage. That will help us create a set of standards and a set of practical applications that we can begin to regulate around over the course of time, but we don't need to be reactive, as is our wont.
Yeah, this question of defining AI is really important. We saw that with the EU AI Act. And I think maybe we are thinking too narrowly, and a lot of people now just equate AI. I mean, in one sense, everything's AI, but then sometimes when people drill down a little bit, it's like they're only thinking, oh, it's ChatGPT, that's AI. It's much broader than that. I really think we need to think about computational technologies, because one of the interesting things is, I mean, I've had people say to me, I talk about a particular usage, and they say, well, that's not real AI. Like, if it's not machine learning or generative AI, just basic algorithms. You can have a list on a paper, right, with questions and then produce some sort of a decision. Algorithms can harm people that don't have to be all that sophisticated. So we need to, again, think about the harms and think about what we're regulating. And, yeah, overregulation can be a problem, because we want to see innovation in this space. We want it to be responsible. There are big, important questions about national security in this space, no doubt. Just at this program I was at today, the director of research for the National Security Administration for the United States was there giving a talk, right? And so that's really important consideration to think about how AI and computational technologies more broadly are going to play a role in reshaping society and in the national order. It's interesting, though, too, at the same time, So I worry, yes, over regulation, you could lose innovation, you can lose jobs. Companies will relocate to different spaces, but that is not an excuse not to have reasonable regulation that should be put into place. There's also this interesting aspect here where Sam Altman, the CEO of OpenAI, shows up in Washington D.C. and suggests, "Oh, there should be regulation in this space, and anyone who wants to do this should needs to get a license." It's like, whoa, 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 hold on a second. It's like, of course, the big tech companies then that are at the forefront would like to kind of pull a ladder up and say like, hey, you have to do it like we do, and that's the only way you're allowed to do business. So there's some tricky questions around this space, but like many of these questions, one of the problems is it's become totally on the extremes is kind of where people are arguing from, either like no regulation so we can allow innovation, or oh, we need to shut these things down. And of course, there's a middle ground. And the last thing I'll say on this is like, we've got to educate people about these technologies, and all of us in the legal sector, we need to have a functional understanding of these technologies. You cannot be an effective lawyer anymore without understanding these technologies, understanding at a functional level. What are the inputs? How is data processed? What are the outputs? What are the kind of errors they can make? And so that's just going to be table stakes. So if you're not learning it in the classes you're taking in law school, then seek out resources so you can learn about it. Coursera, webinars, all sorts of different things, because that's going to be crucial for you.
Can I just add to that as well, that I think it's also so like I agree completely about it's important that we be learning about it. And I think especially like learning what it actually is and distinguishing that from the hype and the big hype cycle that's been happening for the last little while, but also understanding its very serious limits. I mean, just to cite a recent situation in BC, although I know this has happened in the States too, a lawyer was caught having used ChatGPT to produce filings, and then it included cases that don't exist, right? So, distinguishing both the reality of it from its overhyped PR, perhaps, and then also understanding the very serious limits of like, what can this system actually be useful for? And then what are all the other applications that this system isn't maybe the right one to turn to, where I need to look to something else?
Well, I think this relates to something you said earlier about like this existential threat question. And, I think for the most part, that's overblown. And I think people use that to kind of like, we even saw an article from someone at Microsoft Research talking about, teasing artificial general intelligence or something like that. And it's like, this is not artificial general intelligence. Now, if you change the definition of it and, scale that back from what, this is kind of a made up definition anyway. I do think, though, these tools are very, very capable. And one of the things we'll see is I think we'll see a little bit of fatigue this next year, that people will start to realize, oh, it was overhyped a little bit, and maybe it can't quite do all the things people said. But I think there are also people out there who are doing the engineering and the hard work to create systems that can solve specific problems, including legal services delivery problems. And so, we'll see some innovation in the first 2 years, but I think in 10 years from now, we're going to see a ton of innovation. And that's just even assuming the technology were to stand still. But I think most sober computer scientists and others would tell you like this idea of artificial general intelligence, the singularity, whatever terms you want to use. I mean, we're many, many, many monumental breakthroughs away from having something like that. Some people might disagree, but I agree, kind of like getting your arms around, well, what is the state of the art? Because if someone can just basically tell you it's magic and you have no way to ask them questions about that or press them on that, then how can you be effective in this space?
And I would add to that, even those who are working in the general intelligence sector, are some of which are saying that that's 400 years in the future. We're not going to see a computer that has the full functionality of the human brain in our lifetimes. So going back to the question of hype, I would remind us all where that comes from in large part is the Gartner Association, who have created a hype cycle for new technologies. And it is a sine curve. So think about the peak of that sine curve as hype, meaning it's overgeneralized, it's overly promoted, it is not understood to be in its best use, followed by a decline into the valley of despair, in which the hype is now exposed. We realize it's not what it was promoted to be, and there's a lot of disinterest and skepticism around a technology. However, what happens in the Gartner hype cycle is it achieves a plateau of productivity. It comes back up above the way things were prior to that technology in terms of performance and trust and productivity. And even though that's an analogy, I think we should be thinking about what does AI, whether it's generative AI or something as simple as spell check, where is its optimal use? And we've already addressed the fact, let's deal with the risks, but let's also recognize that we're not going to be able to do our jobs without AI, regardless of the application. And I think those who are using it in the legal sector also will understand the very difficult time large language models have with legal questions. There was a Stanford study just released last week that shows when you direct a general AI at legal questions, whether it's ChatGPT, Bard, Copilot, regardless, there's as much as a 75% error rate because of the complexity of law and the nuances of legal search. So again, that's a risk. Let's add that to the category of things to be avoided and become more intelligent about the use of AI and how best to seize its advantages and avoid being conflated by its risks.
Okay, thank you. For my next question, I'd actually like to kind of circle back to a comment that Larry had made about the need for an interdisciplinary approach to regulation. So given the immense technical complexity involved in creating complex AI applications, how can lawmakers ensure that the regulations that they're enacting are being developed with appropriate input from the individuals who do have technical expertise in creating AI?
Do you want to go the same order again?
Same order, please.
I mean, the first thought that comes to mind with that question is actually almost the opposite of what we rightfully need to talk about, which is the ways that we've seen in the last year or so how the heads of some of the big tech companies can actually really throw lawmakers off the right path, or what I would argue is the right path in terms of what they should be focusing on. Potentially because of sort of an effort to hype up different systems or to really oversell or arguably oversell where we're going to be in the next year, 2 years, 3 years, what it is that lawmakers ought to focus on. And this goes back to something that Daniel said too about how, there's also an incentive to make it so like we're going to make it harder for new or other parties to get into this market by focusing legal attention on what we already do, and others are going to have a more difficult or expensive time trying to keep up with. We've seen that in other hype cycles as well. I mean, sidewalk robots, it was a baby hype cycle compared to generative AI, but sidewalk robots went through like a mini hype cycle a little while ago. And there was one really prominent sidewalk robot developer, who basically persuaded or lobbied a whole bunch of different states to adopt laws that really fit with its design, and then made it really hard for other designs to enter into the market. And, I think there's still debate on what value we truly get as a society from sidewalk robots. I don't doubt that there are some values. Anyway, that's a whole separate conversation. But I think it is really crucial that lawmakers are in broad consultation, because nobody expects lawmakers or judges or lawyers to have expertise in everything. And I think it's very naive to imagine that one could have that kind of expertise in everything. Something that was a bit disappointing to many in civil society with the AI and Data Act development was that it seems that there was some consultation, but it was only really with the technology side of expertise, and not with other, not with a whole cross section of other parties that have an interest in how AI is regulated, in advance of actually drafting up the legislation. And the legislation has now been critiqued from a number of different angles, and I think that's where my sense is that there's going to be some broad sweeping amendments recommended. All that to say that like it is so crucial that there's consultation, but I think that consultation has to engage a pretty sweeping range of expertise if we want to have a sweeping kind of regulatory regime developed. On the other hand, as has been mentioned a few times, like if we identify specific risks or issues or harms and create prescriptive legislation that deals with those particular risks or harms, the consultation could maybe be also simultaneously a little bit more tailored, where you talk to, who is it that experiences this harm, who will have their own important expertise and insight, who develops the technologies that might engage this kind of harm, and who, has the expertise in sort of the civil rights or other kinds of legal rights that are engaged. So I mean, it really depends on what kind of legislation we're making, but I think it is so important to have consultation with people who actually understand how the technology works, but to exclusively focus on that and to exclusively focus on those who come from the commercial side of the development, I think is a huge weakness in the development of regulation. So it's got to be interdisciplinary, but also what would be the word, like inter-experiential. Like we need the experiences of a range of people who might be affected by the law and by the technology.
And for example, as we think about the panoply of interests that Kristen just referenced, we also readily understand the power of economic self-interest, and therefore discounting to some degree the input of individuals or entities that have significant economic interest without ignoring the wisdom and the experience that they bring to the table. Sometimes that can be difficult. But other stakeholders, such as access to justice, such as a whole industry of AI assurance. That's not insurance, that's assurance. There are probably close to 500 businesses that exist not to deliver AI, but to test AI for its accuracy, for its reliability, for its transparency. The bias issues can be both, as Kristen said, in the algorithm and in the data set. So some degree of auditing is increasingly going to become apparent as I think these regulations begin to take shape. And already in those instances in which that has been done, such as in New York, and I think it's implicit in the EU, that third-party review of a particular AI application is going to be the norm. And those businesses that provide the assurance by being those third-party auditors, if you will, I think is another stakeholder that has to be a part of this conversation. So think creatively, think broadly. Who are the entities, industry sectors, and even individuals who have an interest of some description in the way in which AI is continuing to be developed? And those public audits, those public hearings, that needs to be above the board. It can't be in secret. So we need to have a much more public dialogue than perhaps we're accustomed.
Yeah, I agree completely with everything Kristen and Larry are saying. I do think, though, we're kind of at the early stage of this, and broader stakeholder groups are important. I just think we need to get expert technologists engaged in some of this, though, in so many of the conversations. And, the CEO of OpenAI is not an expert technologist. It's more about marketing than it is. I have a ton of respect for Sam Altman. I respect Elon Musk and many of the things he's been able to accomplish. They're not AI experts. Mark Zuckerberg is not an AI expert. They're held up as AI experts in the press and so on. So we need to there's tons of AI expertise out there. Some of these people are involved in the discourse, but I think it's really important to get them involved. Law schools is a space where we need to do this better too. Academia generally, we tend to be very siloed. I went all through law school, and I very seldom had exposure to people from other disciplines, from the business school, from engineering, from other parts of campus. So I think that's a place where we need to model this better ourselves. And there's too many conferences we have in this space that we don't bring computer scientists in. We've got a lot of lawyers like ourselves on this call that have a fair bit of expertise, but that's not our job every day, every hour. I work with someone in computer science. I work with multiple people in computer science who have been doing this for decades, right? That's all they do. And we got to get more of those people involved in these conversations. And really, that's a model for so many of the things that we're going to experience as lawyers. Like I said earlier, we need to develop a functional understanding, how to be able to talk about these things and ask intelligent questions. But absolutely, we have to rely on people who have deep expertise if we want to be able to work on these problems effectively.
Larry, did you?
Yeah, thank you. I would just add, in the arena of expertise. Fortunately, some of us have access to and relationships with those technologists that Dan has identified. I'm fortunate to be associated with Dr. Adele Elmasiri, who's taught me virtually everything I do know, as limited as it is, about AI and other emerging technologies. But in that vein, there are institutions such as the International Conference on AI that bring in those multidisciplinary experts into the dialogue. So being aware of offerings that are multidisciplinary and that have both law, policy, technology, let's find those as well to learn from and participate in, because they help us broaden our understanding of these emerging technologies.
All right. Thank you for that. We've had a very robust discussion of these issues, and I've noticed there's been a lot of agreement among our three panelists, and I think you've done a great job of painting a fairly coherent picture of kind of what the issues are, and sort of what are the additional issues that policymakers need to keep in mind going forward. So this has been very informative. I have some more prepared questions that I could ask, but I'd like to give students, the audience, the opportunity to ask questions. So we've got, maybe 10 minutes if we push it. So we've got a lot of people in the room. I imagine that there's some questions from students. So why don't you just raise your hand if you have a question and go for it. Yeah, and if you could just use your desk mic so it catches up in the recording. Yeah.
Sure, thank you. I have a question about the often assume the neutrality of technology generally. Like I worked in corporate finance before I came to Allard. I have kind of maybe not so accurate observation that often the crypto people who celebrate the decentralization of crypto technology are now the people who embrace generative AI or other more popular topics. But if you just, I think in a way, the empowerment or the allowing the companies to have access to such a huge amount of information is risky because it could generate a new form of totalitarianism. But if just imagine if we put the government in a position to access all these kind of messages and information, everyone will think, oh, it's probably wrong because we need to restrict the power of the state. But when it comes to the technology companies, seemingly we do not have that kind of concern. I would like to hear your opinions on this kind of neutrality. Thanks.
I'll jump in real quick. I mean, I think it's an interesting observation and concern. I mean, when you mentioned the crypto tech, I don't know if you were kind of alluding to, I mean, there's kind of these running jokes on Twitter about the grifters that kind of just went from, the latest hot thing to the newest hot thing. But that's another reason why we have an obligation to learn about these technologies so we can ask good questions and figure out like who are the real experts and who are the grifters, things like that. We mentioned, I think, just US and Canada and the European Union, but we really need to be looking at legislation all across the globe. There's a lot of really interesting things happening in China and regulating these different technologies. And so I think, from a Western perspective, looking at China, we think, well, it's the opposite there. The companies are closely regulated and the government has a lot more leeway to do things with data. But I agree completely. We have to think about how these companies are using data. And there's so many questions around it. Just, just a small anecdote before I came to New York on this trip. I was looking at hotel prices and I was logged in on my iPhone and on my laptop, and I was getting very different prices from the hotel chain. And I was shocked because I know that there's price discrimination. A lot of people are surprised to know that that's not illegal unless you're discriminating based on some protected attribute. But just I was logged in, so they knew who I was, and they were doing that pricing that way. And that's an example of something where when these companies have that kind of data, like they can map it out. And I ended up waiting until I got to New York to get my room. But at some point in time, they'll know like what my little game is and when I think I'll get a better price. And then, maybe they can say, oh, look, now he's at LaGuardia, let's double the price, right? And so these are the kind of concerns I think we should have when companies have so much data, we're just scratching the surface on how they might manipulate us, right? It's not. This is the thing about misinformation as well. Misinformation is a problem, but using 100% accurate information, you can feed information to people in a way to get them to change their perception of the world. That's really powerful, and it's not misinformation. So anyway, I don't know if that really directly addresses your question, but those are some thoughts that come to mind.
And I would add that to that end, these are the things that I think it really warrants some reasonable degree of regulation. I would think about all of the innovations that we have seen over the course of time, which came on the scene and could have wreaked havoc with both the economy and individuals. I mean, go all the way back to the steam engine. Think of the people who were impacted when horses were no longer the primary mode of conveyance. Well, over the course of time, what we have done is install guardrails around all these innovations. It's become normal. If we think of the automobile, if there were no regulatory constraints on how automobiles should function, if there were no rules of the road, if there were no engineering standards, it would be so dangerous to get into an automobile that we probably would not do it. But this is no different. The sophistication of new inventions and innovations does not suggest that we should take hands off, nor the opposite. Centralize control over the operation so that I think the message that I'm hearing from this panel is it has to be interdisciplinary, it has to be responsive, it has to be intelligently focused on the risks, while at the same time encouraging the innovation, the development. And that's not always an easy balance to strike, but it's essential with this vital tool that all of us will become very reliant upon in the work that we do.
Yeah, just to add one last thought, I mean, I agree with the comments that have been shared, but the thinking, you're right to point out, I think also some of the thinking around how folks who were very heavily invested in the crypto hype have now shifted into the Gen AI hype, and then they'll shift into whatever is next on the horizon. And it always comes back to a reminder to me, like in my mind, it always comes back to a reminder to me to separate the idea of innovation from the unrestrained and unrestricted ability to accumulate capital. And I think that sometimes that concern about, law is going to inhibit innovation is actually law might slow or restrict some individual's ability to accumulate more and more capital. But in many ways, that kind of regulation can actually allow more innovation to flourish, which doesn't exactly go to your crypto point, but does go, I think, to the idea that these, even though the Venn diagram might overlap in a lot of ways in North American history, these are two distinct considerations and concerns, and we can maybe try to work on doing both simultaneously. And it is, I think, really evident when we have big hype cycles like the two that we've had recently, how those two can get caught up and tangled together.
Do we have maybe another question in the audience? Yeah, go for it.
My question is, I guess I'm an AI researcher turned law student, so I'm quite a bit more bullish, I think, on the technology than you three are in ways that I'm very concerned about. But I guess my question would relate to, I feel like currently the internet writ large is a bit of a legal vacuum with not much regulation. And I think the next step in AI is going to be a lot of AI agents that are capable of acting autonomously. And to me, that does pose a lot of novel legal questions, because it certainly expands the realm of something like using negligence to try and contain this. If you can develop an AI that can then go out and act in the world, or at least online on its own. And I'm curious if you have any thoughts about sort of how, since we've failed to effectively regulate the internet and AI thus far, how something that to me poses so many more complex challenges, what you think an approach might be to regulate that would be.
My first thought in response, I can't help but say, my mentor, Ian Kerr, wrote a paper called Bots, Babes, and the Californication of Commerce. I don't even remember anymore what year it was published. I think it was in the late 90s. And it was about, I mean, obviously you're talking about a much more sophisticated type of autonomous agent operating online. Like, I'm not trying to draw a direct analogy in the technology, but it was all about how is the law going to respond to autonomous agents. And he focused, I think, in that paper mainly on contract law. But the reason I say it, well, the reason I can't help but bring that up is that, I mean, in many ways, even though some technologies, perhaps especially those that are on the imminent horizon, are going to raise novel legal issues, a lot of the base problems have existed for a really long time. And I mean, I've been thinking about this with deepfakes. It's true with what you're talking about. It's true with recommender algorithms. It's true with all kinds of different systems that we're talking about. The core issue that we're really thinking of is a social problem that we have either ignored or failed to adequately address, that is now exacerbated through different types of systems. And Liam, you can push back if there's something more particular that you're thinking of that doesn't track with that. But I think in a lot of ways, law is only a sliver of how we're going to respond to some of these challenges that are happening now and that are on the near horizon. And so, I mean, obviously, thinking about how would something like negligence law be adapted to novel challenges, it is really helpful to get prescriptive thinking on that. And I think some prescriptive guidance is good for a lot of different reasons, including just an attempt at dissuading, even though that's not always going to be effective. But at the same time, I think that, you know, if we could actually deal with some of the root causes of some of what we're talking about, that might be an actually more effective mechanism than trying to legally deal with how things are exacerbated through automation. I'm not saying I'm overly optimistic that's going to happen, but this is just where my mind goes, is that there are other ways that we could target some of these problems, which can include law, but might not be necessarily legal regulation of a particular type of automation.
Okay, so I'm going to let Kristen have the last word there, just because we're gonna be hustled out of the classroom. So we could talk about this stuff for like another hour. This has obviously been, a great conversation. I have a lot more questions. I'm sure other people in the room have more questions, but we need to wrap up. So thank you so much to our presenters. Let's get a round of applause. I'm not sure if that picks up on the mic, but there was just a very robust round of applause. So thank you so much. And I will let you go, but thank you again, and thank you everyone for attending.
Thank you all.